Okay, welcome back. So our next panel is a Silicon Valley Spotlight. It's unique at this conference in that instead of looking at the issues through the lens of a specific regulation or enforcement program initiative, it really looks at it through the lens of industry and specifically the complex world that is Silicon Valley. And we have a great moderator for this panel, Shannon Eagan, a partner and the Northern California head of Cooley's business litigation practice. Shannon has been a leading SEC defense attorney in Silicon Valley for almost 2 decades now and has built a truly impressive reputation, especially in emerging technologies and sciences. In fact, she played a role in some of the most significant disputes impacting Silicon Valley, including disclosure of clinical data by life sciences and also stock options backdating issues. Welcome, Shannon.
Thanks, Bruce.
Let me next introduce Gavin Masuda. He's a partner in the San Francisco office of Latham and Watkins. His practice has a particular focus on advising accounting firms. He's represented Big Four accounting firms and some of the largest corporate failures, financial frauds, and restatements of the past decade. He's also very active in the securities litigation and enforcement areas. Welcome, Gavin.
Thank you, Bruce.
Eric Poer is a senior managing director with FTI, where he's not only the co-leader of the securities accounting and regulatory enforcement practice and the labor and employment practice, but also the Western leader of his North American disputes practice. Eric basically has every credential you can get in the accounting and finance areas: a CPA, certified fraud examiner, certified in financial forensics, and he's also accredited in business valuation. And for over 20 years, he's been using this experience in accounting and finance to help his clients in Silicon Valley and beyond. Eric, you're the perfect consultant to have on this panel. Really glad you're here. Thank you.
Thanks, Bruce.
Finally, from the SEC, really pleased to welcome SEC Associate Director Monique Winkler, who oversees the San Francisco Office of Enforcement efforts for Northern California and the Pacific Northwest. During her more than decade-long career at the SEC, she's investigated or supervised cases against Theranos, Elizabeth Holmes, LendingTree, Keygen, all local actions with global ramifications. So as the regulator overseeing enforcement in Silicon Valley, it's really great to have Monique as a panelist here. Monique, thanks so much for joining us.
Thank you, Bruce.
Let me turn it over to Shannon.
Good morning, everybody, and welcome to the Silicon Valley Spotlight. We're going to cover, as Bruce said, sort of a potpourri of things that are all Silicon Valley enforcement related. Monique, it's been more than 5 years since former Chair Mary Jo White stood about a mile from here at Stanford University and announced the Silicon Valley Initiative. And since then, we've seen some prominent actions from the SEC and in particular, your office in San Francisco against venture-backed companies and venture capital firms in the Bay Area. Of course, we can't really talk about Silicon Valley without talking about the venture capitalist space. Tell us about some of the actions that you all have brought this year in that world.
Thanks, Shannon. And I'll start with the usual disclaimer here. The views I express today are my own and do not necessarily reflect those of the SEC staff, the commissioners, or the agency. So I think I'll start with the Golden Boy case, since it is pretty basic focused venture capital. And just before I get to that, I looked back and I saw that last year I talked about revenue management, data privacy, and insider trading cases, among others, on this panel. And there's different types of cases to discuss again this year, but I think the common theme is that the SEC and the San Francisco regional office in particular continue to bring cases focused on Silicon Valley and the Bay Area in the venture capital space. So the Golden Boy matter was a subtle matter that involved misappropriation by a Silicon Valley venture capitalist from the private capital fund that he founded and advised, Golden Boy LLC. According to the settled OIP, Alexander Gould used the assets of the fund to pay for various personal expenses, including debt to another fund that he had previously managed, his mortgage, credit card debt, and travel expenses. All total, he misappropriated more than half of the total capital invested in the fund, which was a little over $500,000, I believe. He settled to the SEC charges, and those included violations of Section 2061 and 2062 of the Investment Advisors Act, bars, and also paid disgorgement and a penalty. So, I think this is just a pretty straightforward misappropriation case, but it happened to be in the venture capital space. And just shows that space is not sort of isolated from any of the usual problems we see, typical fraud.
Yes, I know you've had some experience recently with another case related to a venture firm. Tell us about that.
Yeah, I did a investigation about 3 years ago of Rothenberg Ventures. It was a small venture capital fund based out of San Francisco, focusing on the augmented reality and virtual reality space. And we got a lot of press at the time. I think ultimately the SEC achieved this settlement with Mike Rothenberg, who started that last year. But it's along the same veins of what Monique was talking about with Golden Boy is, I think emblematic in some of these, venture capital agreements, they don't specify each and everything you can do with the funds. It's more of a general statement about using the funds for the benefits of the investor. And that can just, in my opinion, that can become problematic pretty easily, because you can have a view that you think somehow traveling to XYZ or having a party with the founders and investors and on your birthday at Giant Stadium with Chance the Rapper is good for the ecosystem, but other people might have views that that's misappropriation. So to me, that's the big takeaway is these smaller venture capital funds are like smaller startups, and they don't have a lot of control. There's not a lot of rigor. Oftentimes the people running them treat it a little bit like their own checkbook. I don't think it's all, ill intent. It's just, lacks some of the controls of more sophisticated, that exists at, say, Kleiner Perkins or, larger funds. So that particular case, I believe people learned about it from an article in the Mercury. They called him the Great Gatsby of Silicon Valley. So I think it was a big win for the SEC, and I think it just preceded this last year.
So coming out of the Silicon Valley Initiative, we've also seen cases brought against private companies. Years ago, we thought, wow, this is new. The SEC is interested in these private companies. Of course, it's kind of old news, but still active news. Monique, tell us about the recent examples of SEC enforcement actions that your office has brought against private companies in Silicon Valley.
Sure, I'll talk about three of them. Three companies, either in Silicon Valley or based in San Francisco: UPlus, Benja, and Ubiome. They were all cases involving Bay Area private companies, notable because they all included charges against the CEO or former CEO, and they were all filed along with litigated parallel criminal actions. They were also litigated along with parallel criminal actions. And the facts all seem to sort of follow a common theme of companies getting ahead of technologies or business models in representations to investors and prospective investors. In UPlus in particular, which was a private Mountain View-based technology startup that purported to have developed a machine learning tool to analyze videos on the internet, we charged the company and the CEO with defrauding investors of approximately $11 million by making misleading statements about the company's finances and sources of revenue. According to the complaint we filed, the founder and CEO raised funds from investors while repeatedly misrepresenting, the company's financial condition. He falsely told investors that UPlus earned millions of dollars in annual revenue, had more than 100 customers, including Fortune 500 companies. Here in this case, according to the allegations, when one investor pressed the founder for information substantiating those claims, he allegedly provided the investor with falsified bank statements in an effort to conceal the fraud. And I think that's a sort of a common theme in some of these specific efforts to conceal fraud from investors. And the CEO here was also charged, as I mentioned, in a criminal complaint filed by the Northern District of California, United States Attorney's Office.
So there are many of these cases that we're going to talk about, including UPlus, involve private company executives deceiving investors, but these investors are venture capitalists, some of the most sophisticated investors in the world. What are the lessons to be learned from these cases from your perspective?
Yeah. You know, I was dusting off my 2016 notes from this panel shortly after Mary Jo White delivered her speech 5 years ago at Stanford about the Silicon Valley Initiative, and just to refresh my recollection about everything we could think of about how this was going to play out at the time. And really the biggest thing, the takeaway was, I don't believe, there was a lot of talk about unicorn valuations at that time. These private companies were getting skyrocketed valuations. Those have gone up even higher. So I don't think, we haven't seen some of the problems that maybe people were anticipating because they just continue to go up. Maybe that'll change in the future. But from the speech, it was less about protecting sophisticated investors who have the ability, if they want, to conduct, sophisticated due diligence, and it had a lot to do with protection of employees as well. Because, when they issue stock for compensation for working at the company, it's virtually impossible for an individual employee to figure out the valuation of that, because that's the culmination of, oftentimes 30 to 100 pieces of information. Is very sophisticated to try to determine that. So, they're very sort of worried about that. So, I think the takeaway for me is from 5 years ago is we haven't really seen a whole lot on the valuation front because things have continued to go up. So, the tide hasn't pulled back yet. But, the basic blocking and tackling that needs to happen in the financial books and records, the capital formation in Silicon Valley is often done off of, co-investing. Intuition is not the same level of due diligence typically that you'd see in a large M&A deal. So people don't vet things the same way. And I think actually in my experience, the SEC is quite mindful of, they don't want to squash the capital formation. I mean, everybody's pretty familiar with, you can't have, the same controls you would have at Google that you can at a startup, and the same processes. So they don't want to squash that. So it's a careful balance that you have to be moving from running a business, like it's your private company with a checkbook and you're the only person that affects, to something in between. So, and I mean, obviously some of these cases that Monique was talking about, that's a straight up fraud. They're creating fictitious bank statements. So, that's of a different ilk than just not having controls. That's something I don't think any of us want to see.
Monique, tell us about Benja.
I think this is another one that it probably falls into the straight up fraud category. In this case, the SEC charged a San Francisco-based e-commerce startup and its CEO and alleged that they misled investors about purported contracts with well-known consumer brands. According to our complaints from about 2018 to 2020, the founder and CEO told investors that Benja was a successful online advertising platform that generated millions of dollars in revenue from popular consumer brands and retailers. And the complaint alleges that Benja never did business with any of these. In fact, the complaint alleges that in order to secure investments from venture capital investors, the CEO enlisted his associates to impersonate representatives of the purported customers, and also even a venture capital fund who had allegedly also invested. And the CEO also purportedly provided investors with forged documents and doctored bank statements. Again, this is another case where the U.S. Attorney's Office filed a complaint against the individual as well.
Gavin, we're going to talk a little bit about this with Ubiam, I believe, but also with Benja. What's the advice you would give to a GC at a private company like Benja or Ubiam, where I believe some of the charges were with respect to lying or hiding things from the general counsel?
All right, that's a great question. And, I think to the point of the common thread in these cases and what we've seen just generally over the last 5 years is that you have seen such tremendous growth, and you've seen that growth happen so quickly. And I think that what you see in these cases are people who start these companies and who get wrapped up into that growth and get wrapped up into the story that they have told themselves and that they have told investors. And so as a lawyer coming into one of these companies, it's super exciting. You know, you come into this fast moving environment, but you may be the only lawyer. You may have come from a law firm. You may have come from a larger corporate counsel department. You go to a startup, you may be the only lawyer there, and you're all of a sudden caught up in this momentum of growth. And I think what's important to keep in mind is that as a general counsel, as a lawyer, you know, well, not in the same sense as like a board of director or the auditors for sure, you know, you do play some sort of a gatekeeping function. You may be asked by auditors to sign representation letters. You know, you may be asked by auditors as part of fraud SAS 99 inquiries, whether you are aware of any fraud. And so it is really important that you keep your antenna up. And I think uBiome maybe is a perfect example of this, where I think you might see, and not to get ahead of Monique, but you might see the general counsel asking questions around the edges of what was going on. It is really important to keep your antenna up. You know, you do play an important role in terms of, you know, quote unquote gatekeeping with the company.
Monique, tell us about uBiome.
Sure, and I think this is probably the one that most folks are familiar with. I think uBiome got a lot of press in the Bay Area, more so than the other smaller companies, and definitely had a bigger capital footprint. So the SEC charged the CEO and the chief science officer who co-founded this company, allegedly a private medical testing company, with defrauding investors of about $60 million by falsely portraying itself as a successful startup with a proven business model and strong prospects for future growth. I think we all probably heard uBiome self-described as it was inventing the microbiome industry, making products to improve people's lives. The SEC's complaint alleges that the defendants lied to investors and prospective investors about ubiome's track record of receiving health insurance reimbursement for its clinical tests. And this was sort of the model they were going to continue to earn and grow on. These tests purportedly could detect microorganisms and assist in diagnosing disease. And I think that sort of gives some of us probably a little bit of a flashback to Theranos. The complaint alleges that these claims were false and misleading because ubiome's purported success in generating revenue depended on actually duping doctors into ordering unnecessary tests and other improper practices directed by both of the defendants, which, if discovered, would have led the insurers to refuse to reimburse uBiome. I think I'll let Gavin talk about the particulars of the in-house counsel there.
Yeah, sure. So just, you know, real briefly, because I touched on this before, but as far as I understand the allegations, you know, you do see the general counsel, you know, alleged to have asked questions, alleged to have informed the founders, the indicted persons at uBiome, you know, about sort of the edges of what they were permitted to do. And then according to the allegations, you know, the founders went ahead and did it anyway. But these, I think, are a perfect example of a situation where, you know, as the general counsel, like, you know, is it enough for you to advise about what may be the boundaries of what you are permitted to do? So you need to also ask, hey, what are you actually doing, right? And I think, you know, the line was clearly drawn in uBiome. I think that it can be a difficult line to draw, and it's not always clear.
So Gavin, with uBiome and uPlus, these SEC enforcement actions were brought in parallel with criminal charges from the U.S. Attorney's Office. From your perspective, are these cases anomalies? Should private companies be thinking to themselves, well, so long as I'm not doing anything criminal, I'm not going to get, you know, in trouble with the SEC? The facts are, you know, pretty clearly across the line when you've got fake customers and forged banking statements and contracts and such. Mm-hmm. What's your thought on that?
Yeah, so I would say to the first question of whether these cases are anomalies, I would say no. A lot of my personal experience over the past 5 years has been, you know, more in the investment fund space. But we have seen, you know, many criminal investigations, indictments that accompany SEC charges. So, for example, you know, direct lending investments, Equitas Capital, you know, we were involved in those from the auditor's perspective, and you do see parallel SEC charges and criminal indictments. But to the second, so is it an anomaly? No. But to the second question, should IPO companies who are not engaged in criminal conduct be concerned about risk? I think the answer to that is yes. I think you should be concerned about SEC risk because the SEC's mandate, right, the anti-fraud provisions, absolutely apply to private companies. And I think those provisions, certainly can be enforced absent a criminal indictment. And while these things often proceed in parallel, sometimes you don't actually know which one of them or if all of them are going to be filed. And so, the SEC can and does do things separate and apart, obviously, from whether, the Department of Justice is pursuing a criminal indictment. So I think it is, you do have to be concerned about it.
Gavin, sticking with this private company thread, what are you seeing as a private practitioner, with respect to private companies in your practice?
Yeah, I think where we are, and to Eric's point about valuations being what they are, right now it's really all about pathways to the public markets. And, if you're a more mature company and you don't need to raise capital, maybe you're thinking about, do I do a direct listing and go to market that way? You're monitoring the market to see which company will be the first company to do a capital raise in connection with a direct listing, which is something that the stock exchanges and the SEC have just authorized. And if, you're maybe an earlier stage company, you're thinking about, well, can I do a SPAC, right? I mean, SPACs obviously are, all the rage, probably across the country, but, especially in the Valley. And so, there's so much concern about how do we do it? When do we do it? What do we need to do in order to do it once we decide all of those things?
Said the magic word of 2021, SPACs. Until a few weeks ago, the SPAC trend was white hot. We've seen activity slow a little bit as the market is addressing changes that it needs to make based on the SEC's announcement regarding warrant accounting. But the fact remains there are still so many SPACs out there looking for targets. And that begs the question, Eric, of internal controls. Acting Chief Accountant Paul Munter recently advised SPAC target companies to consider the sufficiency of their internal controls environment in light of public company requirements. How can sponsors and target companies prepare for these requirements and stay on the right side of Monique and her colleagues at the SEC?
Yep. Well, as it relates to Paul Munter's, recent guidance, and I will say, I think in 2 weeks he's doing a presentation with PwC. So stay tuned for some more information coming on that. But for private companies, in addition to the anti-fraud provisions, I mean, there is a general. I think it's a misconception that you don't have to have internal controls, any formality, which is not true. You absolutely do have to have a certain level of internal controls, and I think the hook ultimately goes back to the 1970s FCPA Act and books and records. The difference is, if you're a public company, you actually have to have a separate opinion on your internal controls. So that means, they have to be more robust. They obviously get audited by your independent auditors, but the requirement for private companies still exists. So in my, from my experience, and I'll tell you, this is a very large area we're doing very significant work at FTI, is on the target companies for the SPACs. They're not, probably not ready for an IPO, which is why, they're looking for SPAC entrance into the market to get them from, early stage private company to the next day or next couple months being ready to have the internal controls and the requirements of a public company. It's a lot of work. And I think that, it's just like trying to bring them up to speed as some of our biggest, projects we work on today.
As Susan Restley mentioned this morning in her One Big Thing, projections are obviously a hot topic right now. Last month, John Coates spoke about the unprecedented surge in SPAC activity. And of note, he questioned whether SPACs have the protection of the PSLRA's safe harbor. Gavin, this is, of course, an increasingly hot topic. How are you advising your SPAC clients with respect to projections?
Yeah, so the acting director Coates' comments were certainly noted. And since then, we've seen a lot of speculation about whether the SEC is going to issue further guidance or do some rulemaking on the topic. But I would say, and not to, put words into the mouths of our folks who do this every day, but I would say that, I don't think that his comments necessarily change too much as a practical matter in the way we do things. And the reason is because it's not been a secret. It's not really been a surprise that is going to be an argument or an issue that is raised. It in fact had been already raised by the plaintiff's bar. And I think even just yesterday, there was an oral argument in the Waiter case where this exact issue about whether the PSLRA safe harbor applies, was actually argued to a federal court. And, that issue will be decided. So it's something that we've had our eyes on, for some time. And so as a result of that, and knowing that that's a possibility, the advice to clients on the valuation is what you would expect, right? It's your valuations need to be supported. They need to be done correctly. You need to state the assumptions that are supporting your valuations with precision so that if those valuations don't dare to be true, you can, point to those assumptions and explain why they did not end up being what you said they would be. So, as a practical matter, I don't know that the advice has changed so much because I think, we've always been mindful of that possibility.
And with respect to SPAC litigation, you mentioned Waiter. How are you advising your clients to sort of be proactive in that space? And what are you expecting to come?
Yeah, so the trend is clearly on the rise. I was looking at these numbers, and in 2019, there were 6 SPAC-related securities class actions. In 2020, there were 7. And just here in the first 5 months of 2021, we've seen 11. And I think that number is sure to increase and probably outpace the growth of SPACs, even because litigation, as you know, tends to be a trailing indicator. So, we are fully anticipating I don't know if you want to say deluge or whatever, a wave of further litigation to come. Lots of interesting issues like the PSLRA issue to be decided in the courts. And so you absolutely have to be braced for the fact that, your disclosures are going to be tested in a number of ways that can be, that intersect with the federal securities laws. And I would just, pause. I think it's really interesting on the civil liability front. There's just so much movement in terms of the civil litigation landscape right now for public companies. Two matters that I have the real good fortune of being able to work on. One is federal forum provisions on the civil side is something that everybody is interested in. Basically, whether you can, as a company, restrict Securities Act liability to federal court. And that's something that is on appeal right now in the California Court of Appeal and will be decided. Another PSLRA issue is the PSLRA discovery stay. And with, an excellent team from Morrison Forster, we right now have a petition on file with the Supreme Court of the United States asking it to take cert on the issue of whether the PSLRA stay applies in state court. And so the outcome of these 2 issues could really shape the landscape of civil litigation, which, as we're talking about, it feeds back into how you do things because you're always assessing risk and cost and, how does that affect your strategy going public?
Let's talk about some of the other issues that are impacting public companies. So market manipulation is certainly a hot topic across the country. Based on recent remarks to Congress, it seems likely that Chairman Gensler will be focused on market manipulation. He made it clear last week that the concentration of retail orders being channeled through just a handful of market makers was a problem in his eyes. He said concentration usually leads to less efficient markets. Monique, that reminds me of Robinhood, of course. It's become a household name for quite a few reasons recently. Tell us about your office's case against Robinhood.
Sure, and obviously I'll leave my comments to the December 2020 settlement with Robinhood, but I do think sort of brought some of these practices that are being discussed more now into daylight. This settled matter involved material misrepresentations and omissions by Robinhood relating to its revenue sources, specifically its receipt of payments from certain principal trading firms for routing Robinhood customer orders to them, and then also relating to certain statements about the execution quality Robin achieved for its customers' orders. The case also involved charges against Robinhood for their failure to satisfy their duty of best execution. According to the OIP, many of Robinhood's customers received inferior execution prices compared to what they would have received from Robinhood's competitors. For example, in larger value orders, this price difference at Robinhood exceeded the commissions its competitors would have charged. These inferior prices were caused in large part by the unusually high amounts Robinhood charged the principal trading firms for the opportunity to obtain Robinhood's customer order flow. Payments generally referred to as payment for order flow. And I think I'll stop there. I could talk more about some of the retail communications that we allege Robinhood misled their customers with, but I think that's the primary focus of the case.
Yeah. I mean, I think one practice pointer is, be careful what your clients' websites say. It's not just about the filings that clients make with the SEC, obviously. But when I read Robinhood, I see a lot about, what was happening and what was being disclosed in the frequently asked questions, for example. So, we should all be mindful of that. Gavin, when I was growing up, Muddy Waters was known as the father of Chicago blues, right? Now it's something our clients fear and loathe. We are all aware of these short seller reports. What are you telling your clients sort of with respect to such reports, whether there's something they can do beforehand, and certainly what are you advising them to do after they are subject to one of these reports?
Right. So, to the first question of whether there's something you can do beforehand, I think there are certain traits of companies that render them more likely to be targeted, right? Volatility in stock price, large market capitalization. So characteristics that frankly fit the profile of a lot of companies here in the Valley. And so if you are one of those companies, it is important, I think, to, even if you've never been hit by one before, have a plan in place to how you would address it, right? And how, the PR strategy, things like, how you would assess the report if it does come, and just have a general framework of what you might do in those circumstances. Obviously when one actually comes around, it's, our experience has been that people take them very personally. If you're the GC of a company, you've worked so hard to do things and do them the right way, seeing somebody publish these things about your company is not easy to take. So you see a lot of strong reactions, I would just say. And so the first thing is to just stay calm. The market has seen more of these. And so the market, I think, has increasingly understood what these are about and where they come from. And the second thing is, we found it really important to try to disaggregate cause and effect, right? So many times these reports are published to cover market manipulation activity, rather than actually causing a drop in stock price itself. And so, one common type of market manipulation you might see is spoofing and layering, right? When, placing orders without an intent to execute on those orders. And, one of the things we've been working with some economists is either in the context of a 10b5 class action where you're trying to negate loss causation, or, in the context of, hey, do I go approach regulators because I think there might be market manipulation underlying this stuff? You can actually do market-based analyses to try to disaggregate cause from effect and try to figure out, hey, is this a cover for some underlying market manipulation that we maybe really need to, think about approaching regulators with. And then just the third piece is, you should do your diligence sort of on the gatekeeper theme, but, see if there is any there, take a look at those allegations, see if there is anything that does need to be followed up on, but does need to be looked at. And I would just say, think carefully about the company's holistic strategies and priorities before trying to go run to Monique and get her to take action on some market manipulation, because once you do that, you I guess be careful what you decide to ask for. And so the immediate reaction to go run and get regulator action is not always the right course for every company.
And I think we were publicly disclosed as investigating Luckin Coffee, which is a Muddy Waters sort of target. So, I mean, I think it's the basic playbook of, do you handle this at the company, the allegations, or should, somebody independent at the board level be supervising? And I think you have to analyze that very carefully. I certainly would err on the side of an independent look. to give you credibility. So you can get to the bottom of this if it is market manipulation, or if there's some there. There has been some there on some of these. So it's certainly a new avenue for sure.
Monique, let's turn to another public company action that your office brought, Wageworks. What was that issue there?
So this was a settled SEC case, again, against the former CEO and CFO of the company. And before I go there, I just want to say something that came to mind with respect to this case, and then most of the other ones that we talked today. Individual charges are in those cases, and I think that's important for people to note and consider. It's not always the case. Sometimes there's criticism out there about the lack of those, but I think there's a pretty common theme in most of the cases that I'm talking about today, is that there are individual charges involved, and I think it's important. So in that case, going back to Wageworks in particular, the SEC charged the former CEO and CFO with making false and misleading statements and omissions, including to the company's auditors, that resulted in improper revenue recognition related to a contract with a large public sector client. Ultimately, this led to a restatement. In particular here, I want to note that the SEC actually charged violations of SOX 304. So the settlements with both the former CEO and CFO included the reimbursement of certain incentive-based compensation from the period during which the misconduct took place, and then also, in addition to that, the payment of penalties. Specifically, the CEO reimbursed the company for certain incentive-based comp, and then also profits from the sale of stock during the period, and then the CFO for incentive-based compensation.
So this is another example of a company trying to go public, right? And during this process goes public. Eric, if you were on the audit committee of a company like Wageworks that's trying to go public, what are you thinking about? Or, to put it differently, if you were to advise the audit committee member from Wageworks to do something different next time, what would you tell that person?
Right. Well, and I think this is emblematic of some of the things I would say to SPAC companies too, is when you're public, the callback provisions of Sarbanes-Oxley, just as a reminder, it's pretty nebulous. It says if there's a restatement of a financial reporting requirement, query what that means, what a financial reporting requirement is. That could be a financial statement, that could be a footnote, it could be an MD&A. I've seen all of it try to be litigated. So, knowing people really need to be educated on that it is a totally different world, that really everything must be precise. And there's very specific, callback provisions. I think people just think, well, our financials are audited. Yeah, but your MD&A or your 5-year revenue table isn't. Those can all fall into that category. And I have seen people go after companies for those things. So I think that's something really important to know as it relates to the, if I were on the audit committee or giving them advice. I mean, I personally view audit committees as, one of the ultimate gatekeepers. And, I personally believe that, I'm not sure I know that this was done or not done, but you can't just take the information that's given to you. You need to be exercising judgment and, doing an independent analysis if needed, if those factors are there. And if somebody's just telling you piecemeal facts to support something that's been on your books forever, like a receivable, I think your antenna has to be up, and you have to be, you are the gatekeeper. And it's very important for the capital markets. So I think that's the advice I would say, is I wouldn't take a sort of laissez-faire approach. I'd be very sort of proactive, not doing the company's work, but truly supervising the company from an independent perspective in a vigilant way.
Let's talk about non-GAAP financials and disclosures surrounding non-GAAP. What are you seeing in the public company space from your perspective?
Yes, some of the biggest, I would say, things I would classify as investigations we're doing in the Bay Area / Silicon Valley are what I would call terms of service investigations. So this is not the traditional revenue recognition fraud or, accounting isms that we've seen in years past. It's, people using their technology, apps, other things, things are way more automated than when I started this business. I think there's 2.5 quintillion pieces of data, produced every day, which if you were to visualize that, that's, 10,000 Blu-ray discs stacked up as high as the Eiffel Tower every day in terms of data. So, when I did one of my first investigations, back in the backdating of stock option space with Shannon, it was all email. Now there's a whole host of cloud systems and things. It's a whole new ballgame that, your playbook, has to change. So, I think there's been some prominent ones. I think Uber's Grayball matter that was disclosed, it was disclosed first in the New York Times. That one comes to mind where, they were using their sort of technology to evade law enforcement in certain areas, as they were bringing on, Uber drivers in areas that hadn't sort of worked out the regulations. So, it's things like that. But if you can imagine, I don't know if there's other ones I can be specific about, but every time you see someone on Capitol Hill, which is a lot, from Silicon Valley, I think those things are being looked into both by the company and independently, and I do think it manifests itself in very serious, that can affect financials and securities litigation and all these things, because most of the valuations of these companies are about users and how, it's not as much about, bricks and mortar rev rec. So I think that's becoming increasingly important, and they manifest themselves in different ways, from antitrust to, securities litigation to just some senator wants to drag you on the hill type thing. So.
Key performance indicators continue to be a hot topic for tech investors, and we've seen some enforcement actions involving allegations of misleading or false KPIs. Many of us probably focused on the headline of the Wells Fargo case, which is, a $3 billion settlement between the SEC and the DOJ. But Eric and Monique, I'd love to hear, your perspective on that case and your takeaways from it. Monique, maybe you could start.
Sure. I think just very quickly, one important point about that case that does seem to get lost in Wells Fargo's whole fraudulent account scandal is that the securities fraud case was about the inflation of a key performance metric. Wells Fargo used its cross-sell metric as a means of measuring its financial success and continued to do so throughout this period, where the metric was actually inflated by these fraudulent accounts. So I do think it's very important for people to think about the securities fraud case in that perspective, as opposed to the SEC doing something in particular about fraudulent account openings.
How about you? What are your takeaways from Wells Fargo?
Yeah, so I was the lead partner on the investigation for the board of Wells Fargo, and I can talk about it a little bit because we actually issued a public report that's still available in April 2017, and I think that sort of provided a lot of information to the government to really understand what went on at the company. But it's the same thing I was talking about before. Is one of the challenges of that just logistically is that's a bank that was, grew through acquisitions. There's lots of legacy systems, lots and lots, billions of transactions a day. So in terms of what you need to look into something like that, as a team of 50 data analytic people, it's a whole lot different than what a traditional, financial investigation might be about. And, to Monique's point, there wasn't really any sort of traditional financial statement or footnote fraud, but some of these accounts that were inactive rolled up into their cross-sell metric, which is something that, analysts and the like sort of looked at, which is, basically a metric about per household, how many different products do people have. So it sure was a very large settlement. It was a very sort of expensive endeavor. So I think that was a pretty big win for the government.
I know we've got seconds left. So Monique, tell us really quickly, and it may be a foreshadowing of the future, tell us really quickly what the SEC is doing about environment, social, and governance in that space.
Sure. I certainly don't want to get out ahead of our new chair, but I will just note that under acting chair Lee's leadership, we actually announced the start of an enforcement task force on environmental, social, and governance issues, which will apply sort of the longstanding principles of disclosure and fiduciary duties that we always apply to these issues.
We may have to take that up next year.
Thank you, Shannon. And thank you, Gavin, Monique, Eric. Terrific job. Really interesting to look at the issues through the lens of Silicon Valley. Appreciate it. So next up at 10:10 is our cryptocurrency panel, which should be quite interesting. We'll see you all in 5 minutes. Thank you.
Thank you.